Good evening, one and all. Today our section is on intellectual property rights. We have Lawellman sir as the resource person. Welcome, sir. And I'm handing over the section to Lawellman sir. Hello, sir. Hello, sir. Is it audible?
Am I audible?
Yes, sir. Welcome, sir.
I
And we
think
can start
we
the
can.
section.
Yeah, thank you so much. So I'll continue from where we stopped in the last interaction. In intellectual property, we were discussing, we have been discussing patent for quite a few days now. In the last class, we discussed some of the fundamental requirements of a patentable invention. Those fundamental features include, or the fundamental features are, a patentable invention should be novel, it should be non-obvious, or it should have inventive step, in other words, and it should have industrial utility. These are the three basic requirements of a patentable invention. We understood that. But if you think practically, from practical point of view, in order to have a patent with regard to your invention, you may have to you may not have the burden as such, but it will be a requirement that your invention should not fall within section 3 of patent law. Section 3 of patent law, of course, section 4 is also relevant here. Section 3 of patent law mainly speaks about inventions which are not patentable. I've got the slides here. I invite your attention to the slides as well. So I put that not in bold, which is notable. So if your invention is complying with all the three requirements of novelty, non-obviousness, and utility, nevertheless, you may not be eligible for a patent if it is falling within any of the clauses under section 3. That's how we may have to understand that. So we had just started off with section 3, but I'll just go for that once again. We just discussed one or two clauses in that. It's a bit lengthy and important section, but yeah, we may have to go through that. That's important from an examination point of view as well. So going to section 3, cap 3A, 3 clause A, it goes like this: an invention which is frivolous or which claims anything obviously contrary to well-established natural laws cannot be patented. That's understanding. So I've got some examples here, which we discussed. So let's see a very strange kind of clock, which was claimed to be a patentable invention in 1970s in Bombay Patent Office. It's a real life, no, a real experience, a real example. Minutes, and each minute was divided to 100 seconds. So if this is adopted, this is going to create a lot of confusion. Just think of scheduling a session like this in this clock. Tomorrow it may be in a different, no, different time as per the proper established clock. So it's going to be it's going to be a total chaos that is going to happen. So this was not allowed. This could be one of the examples for an exempted, or rather uh, 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 an invention which cannot be patented under Section 3E. So we this was already discussed. So we'll move faster. And this is a picture of such a clock, which I got from Google pictures. So this will make more sense of what we discussed. Just look at this clock and think of the scheduling of various things, including Indian Railway timetable and even our college timetable, things like that. Okay, then we move to the next clause, that is clause 3B, which says that any invention which is contrary to public order or morality. I don't want to read out the entire thing, of course, which is not, which would cause prejudice to human, animal, or plant life, etc., etc. Say so. So anything that is contrary to public order or morality, and which will be, problematic for human life, or plant life, or animal life, cannot be allowed to be patented. That's what it says. So a device, apparatus, or machine, or method for committing theft or burglary. It's a straightforward method, straightforward example, I feel. And similarly, there is a lot of examples which could come within this, a method of counterfeiting, or machine for counterfeiting currency notes. It may be novel. It may have some, it will have definitely a technological advancement in the form of inventive step, and then the third one, the utility too. But nevertheless, it will have the hurdle of Section 3B. And the method of cloning, which has got arguments on both sides, could also have problem under Section 3B. Method of cloning is likely to cause prejudice to human life, and perhaps to plant, animal life, if humans are considered to be, animals. So I think Section 3B can also be, we can just go further after 3B. And 3C is this: mere discovery of a scientific principle cannot be considered to be patentable. An example is finding a new substance or microorganism occurring freely in nature is a discovery and not an invention. So we know the classic difference between discovery and invention. In the case of discovery, it is something which is already existing. Discovery of America is something which we all talked about. Columbus discovered America, or we have got some other people also, some other person also said to have discovered America. We do not know about that, but anyway, America was freely existing. Here, a good example in the patent context could be a simple, a little smaller example, which will make more sense. Finding a new substance, finding a new substance or a microorganism which is freely occurring in nature. That's also important, because sometimes if a person finds that substance, if it is very difficult to isolate and it is not freely existing in nature, then if a person takes a lot of what you call effort to isolate and present it in a particular way, which will be useful to the human beings, then it may be eligible. It will be entitled for, perhaps it will be entitled for patent. But if it is freely existing in nature, and if it is just a mere discovery, then it will not be eligible to be patented. It will have problems under Section 3C. This is where we stopped, and then we will move on from here. And here you have Section 3D. 3D is three-dimensional in the context of films, etc. But when it comes to patent law, Indian patent law, section 3D is famous. Rather, I would say it is infamous in other jurisdictions like United States of America and all, because of just this and decision of Supreme Court. India is in the watch list of many of the what do you call many of the countries, including United States of America. They have included us in a watch list because we don't provide enough enough level of patent protection. We have some problems. That is what they believe. So we have this section here, section 3D. And as it is important, I thought I'll put it in bold letters and we will read that through. The mere discovery of a new form of a known substance. Let's go once again. A mere discovery of a new form of a known substance. It's a known substance, and what you do is a new form of a new substance, and such substance does not result in the enhancement of a known efficacy. This substance, which is already known and only new, its new form is found out, and the already known form has a particular efficacy, particular function that it serves. It's effective in a particular way, and such new form of an already known substance will not be eligible for patent under section 3D unless it results in enhancement of efficacy. The already known efficacy and effect is already there. It's known to the world. Unless this particular new form of the known substance results in a enhanced efficacy. That's a important terminologies we may have to concentrate on. These are the terminologies which put India in trouble in a way, though it is justified, I feel personally. And this was the phrase on which the Supreme Court spent its time. The whole matter started off in the Chennai Patent Office. Then the matter went to Chennai High Court, Madras High Court. Then it was transferred to IPAB. Then ultimately it came to Supreme Court under Article 136. But what Chennai office said was upheld by all the bodies above, including Supreme Court of India under Article 136. So this was the problem. And this is where the whole matter was argued out or fought out. Enhanced efficacy of a known substance of that substance, or the mere discovery of a new property or a new use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. This is science. I also found it difficult to understand. I also found it difficult to read the case which dealt with this matter in India. The case is nothing but Nowhatis versus Union of India. This is a well-known case for me. It is a notorious case for very many, but this is a case which was very much in limelight, and I feel it is still in limelight. Let's understand what happens in Nowhatis versus Union of India. Here, Nowhatis is one of the multinational companies which has got, which is a pharmaceutical giant, we can say, and they've got some medicines, of course they have got, and here the matter was something known as Glyvec, which is a medicine for cancer. It was a cancer drug. It's not that very important for us. And an already known form was patented and it is being used. It's known in the world. And now what they did is, a particular new form, an already existing form is there. I'm trying to make it as general and as simple as possible. Unless you read it, you may find it difficult to understand. So please listen. So the new form, they say that it's something which is novel, and it has got technically it's more advanced. there is technical innovation involved in that. But Chennai Patent Office denied them the right of patent because they said that though this particular form is not known, this is derived from an already existing form, and this derivation of already existing form does not have any additional, what you call additional efficacy. It functions the way it is already known substance functioned. So this derived thing, according to them, according to Madras Patent Office, this derived thing does not have an enhanced efficacy. Its effect is just the same as that of its known predecessor. So this derivation and derived product does not result in any kind of enhanced efficacy. So this cannot be granted a patent under Section 3D. That's what Madras, Chennai Patent Office said. It was upheld by Madras High Court, or rather, it was transferred from Madras High Court to IPAB, which was in existence at that point of time. IPAB is not there now, to my knowledge. And the matter ultimately went up to the Supreme Court, and Supreme Court also said, yes, we see substance in what Chennai Patent Office says. So this is how this section is to be understood. And I've got a few more examples to understand this section, because this section has got other parts too. A similar example could be the paracetamol, which you and I take almost maybe every month, perhaps, especially during the Corona period. The paracetamol has antipyretic property. It already has that property. And if there is a further discovery of a new property of paracetamol as analgesic, cannot be patented, because this is already known substance, and it's one of the functions is already known. Property in the scientific sense would mean its function. A further discovery that it can be used for another disease also will not entitle that for patent under Section 3D, because let us read that again. Let us read the second part. After enhanced known efficacy of that substance, or mere discovery of a new property or a new use of a known process, machine, or apparatus. The example I brought in, the paracetamol example, is an example for the second part, which I just read out. A mere discovery of a new property, new function of a known substance, like paracetamol, will not entitle it for a patent. That's the point. Am I making sense, Mr. Roshan?
Yes, sir.
Yeah. Thank you. So let's move to, if you have any clarification, because it's a bit complex, you might feel. If you have anything to clarify, I'm ready. So that's the reason why I just.
ഈ ഒബ്ജക്റ്റിന്റെ മുകളിൽ പാറ്റന്റ് വേണ്ട, പക്ഷെ ആ ഇന്നോവേഷൻ, ആ പുതിയ ഇന്നോവേഷൻ ഒരു പാറ്റന്റ് ഉണ്ടാവില്ലേ?
But here what happens is, this is just if you are speaking about the first part, which I try to explain through Nowhatis, what happens is there is a derived product, derived substance. This substance is only a new form of an already existing substance, and this derived form of the already existing substance does not have an additional benefit. It does not have an enhanced efficacy in a particular way. If it is effective for a particular disease, and this derived substance is also having the same effect as its predecessor had, then it is not entitled for a patent. That's what it says. Yeah, now you can just put your ideas.
ഞാൻ ചോദിക്കുന്നത് എഫിക്കസിയുടെ മാറ്റർ അല്ല. ഇപ്പൊ ഒരു സബ്സ്റ്റന്റിന്റെ ഒരു ക്യാരക്ടർ നമ്മൾ അറിയാം, ഒരു എക്സ്ട്രാ ക്യാരക്ടർ വേറെ ഒരാൾ ഇന്നോവേറ്റ് ചെയ്യുകയാണെങ്കിൽ, കണ്ടെത്തുകയാണെങ്കിൽ അത് പുതിയൊരു ഇന്നോവേഷൻ തന്നെയല്ലേ? ഒരു എലമെന്റ് ഒക്കെയാണ്.
He's not contributing anything technologically, right? Because take for example turmeric. Today we know that turmeric is good for our what do you call, our skin. And tomorrow, if somebody finds out the same substance without anything, he just finds out that it is useful for what you call fever also. So here, the second element, I would emphasize on that, the inventive step element, because this person does not contribute technologically.
Okay.
There is no inventive step for that. This is just a discovery of something, an already existing thing, to which he is not contributing anything. He's just finding that out.
അതായത് ഒരു കൺട്രി ഒക്കെ കണ്ടെത്തുന്ന ഡിസ്കവർ ചെയ്യുന്ന പോലെ തന്നെയാണ് ഇത് കണക്കാക്കുന്നത് അല്ലേ?
A country discovery was just a wild example. If you can just come down to the level, or come to the context of patent, if you are where you will be speaking about chemicals and things like that. Here, the example I gave, I will go to that again. The example I gave was this: the paracetamol has a property which is already known, and the very same paracetamol has another property. It is effective with regard to, apart from fever, it is effective for what you call ringworm, which is a common thing. If it is effective for ringworm also, the person who says that it is effective for that is not finding anything new, in the sense that he's not technologically doing anything. He's not making any new substance or any kind of mixture or anything. He's just finding out a new property, new function of an already existing thing, already known thing, non-substance.
ക്ലിയർ ആയി സർ, മനസ്സിലായി.
If you've properly understood, thank you so much for the question as well. Okay, let's move to the next one, that is section 3E. Section 3E says that if it is a substance obtained by a mere admixture. What's a mixture? I just had mixture in the evening with my tea. Mixture has got very, very many elements. So when you mix it, it becomes a mixture, right? But that is just a simple example. So here there is a substance obtained by a mere admixture. Mixing is not, sometimes it's an easy business, but sometimes it will be difficult for you to mix certain things also, especially chemically. And here what happens, a substance obtained by a mere, I would emphasize on the word mere mixing, mere admixture, resulting only in the aggregation of properties of the components thereof, or a process for producing such substance. Bit technical, but let's understand it through an example which I've brought here. A mixture of sugar and some colorant in water to produce a soft drink is a mere admixture, resulting into aggregation of its properties, aggregation of its functions. So what happens is, here the person who is mixing is merely mixing it. It gets mixed automatically, in the sense only physical, only a physical contribution is required. There is no great thing of, in certain circumstances, the things may not mix. You might have heard about a liquid wherein gold will get diluted. In the sense, gold will dilute in that, get absorbed. Wherein I think it's hydrochloric acid and sulfuric acid. I'm not very sure about it. I'm not an expert in science. But if that making that mixture requires a lot of effort, technologically wanting effort from the part of the person who is mixing it, then it will not come under this particular subsection. Here what happens is, here it is just a mere mixture, and the resulting substance is just aggregation of these things. So this is sugar, colorant, and water. So all water has a function, colorant has a function, and sugar also has a function, and this mixture has an aggregate of all these functions. That's all. If it is resulting in, if it is mixed in a particular temperature, in a particular way, in a particular ratio, and if it is resulting in certain things, and if there is if it is technologically wanting, then it may not come under this. Miss Pooja, am I making sense? I think she's not there. It's okay, no problem. So similarly, a mixture of different types of medicament or medicine to cure multiple diseases is also a mere admixture of substances and is not a patentable invention. The best example we can think of is the medicines which were prescribed to us during our corona period, like crocin and all the non-substances, some vitamin D, vitamin C, and tablets. Even if it is mixed and if it is results only in the known no functions, then it's one of the examples for this. Let's move on. However, importantly, an admixture resulting into synergistic properties of a mixture is not considered as mere admixture. Example: soap, detergent, lubricants, and polymer composition, etc. Sometimes you make glass out of these things, right? So if it is more than, if it is beyond a just admixture, then it may be entitled. It will depend on what's the quantum of effort, technological effort that was put into this, intellectual effort that was put in, and if it is resulting in synergistic properties, not mere a mixing of already known properties. Okay, let's move to the next. That is 3F. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another, is not in a known way. Let's think of this one. A mere juxtaposition of known devices which each device functions independently is not considered patentable. An example could be an umbrella with a fan. Okay, what happens is just an arrangement of known devices, like umbrella is already known, fan is already known. You're just putting this together. In olden days, we used to have a radio and tape recorder in one device, maybe in one box. Radio is already known, tape recorder is already known, and you can buy radio separately, you can buy tape recorder separately. But if you're getting it together and putting that together does not require, is not calling for a great challenge, then it is not patentable. It is mere arrangement or rearrangement or duplication of known devices. I've got a picture of that particular thing which I got from Google, acknowledging Google Images. And here you can see the umbrella. And if you look inside on the top, you've got a fan also. So you have got a button on the handle, which if you press, the fan started working. Then when you walk, you are on the walk, you get hava from the fan. So here what happens is it is just functioning the way it worked earlier. Here it is just an arrangement so that it is together. So there is no great intellectual effort in it. It's obvious to a person in the arena, and this is not patentable. It does not involve enough of inventive step so as to entitle it for patent. Let's move on. Clock and transistor in a single cabinet, bucket fitted with torch and things like that. Okay. Now moving on, H3H, a method of agriculture or horticulture is not patent. A method of producing mushroom plant. This is a 79 matter before the Calcutta Patent Office, and method for cultivation of an algae. This was a 93 matter before Delhi, Patent Office, were held not patentable. I think we can move on. And now 3I, any process for the medical, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings. Matter you may have to keep in mind is a method of treatment of human beings and animals. It is not, I emphasize, is not patentable. A method of treatment of malignant tumor cells, maybe cancerous, and a method of removal of dental plaque. These are all method of treatment, and these are all patentable. Next one is 3J. plants and animals in whole or any part thereof, other than microorganisms. Plants as such is not patentable, for the reason that you have got a Plant Variety Protection Act for that, and higher level of animals, except microorganisms. Higher level level of animals are excluded from any kind of intellectual property protection, in whole or in part thereof, other than microorganisms. Microorganisms are patentable if, as in the case of Diamond versus Chakravarti, which you might already know. That was the case. Diamond versus Chakravarti was a case wherein the American Supreme Court, for the first time in the world, held that life can be patented. In that way, it's an important case. You may keep that in mind. You may note that down if you are not aware of that already. Plant varieties are protected under Protection of Plant Varieties and Farmers' Rights Act 2001, and there's a spelling mistake there. Let's move further. 3K, a mathematical or business method or a computer program per se or algorithms are not patentable. A business method, a method of doing business, like money chain business, cannot be patentable. A mathematical method per se, that per se is important there, because if you are making a device based on that mathematical method, E is equal to mc square or anything of that sort, that method by itself, that mathematical method per se is not patentable. Pythagorean theorem. But if basing on Pythagorean theorem, if you're going for a device which is useful to the society, then it's not per se. You are putting some effort into it. You have your element in it. Your element. In the sense, the quantum of inventive step is there. Then it may be patentable. So computer program, the software per se is differentiated from software having its technical application in the industry. If we are making a device which works based on a software, then it might be patentable. But software per se is not patentable in India because it comes under copyright law. Moving further, there is section 3L, a literary, dramatic, musical, or artistic work or aesthetic creation is not patentable, like cinematography, film, television products, etc. The reasons are obvious. It comes under copyright. Then comes a mere scheme or rule or method, performing mental act or method of playing game, a method of learning a language. There are different methods in which you can learn a language. So a method of learning Arabic, an easy method of learning Spanish. These are all different methods, and this is not patentable. Method of playing chess or a new game, game. And there are different method of method of playing, different games. And nowadays, especially in the cyberspace, may not be. Method of teaching. So method of learning, all these are not patentable. And a presentation of information is not patentable. Any manner, means of method of expressing information, whether visual, audible, or tangible, by words, codes, signals, symbols, diagrams, or any other mode of presentation, is not patentable. Even even a language. A language is a coding method, right? If you think in that way, a language is a coding method. When you say APPLE, when you say A, when you have a triangle-like thing and you have a line across, you call that code as A. That's a code in a way, and the circle is pronounced as O. So that is another coding. So all these, I was just giving very simple example, but visual, audio, audible, visual, audible, tangible, any words, codes, anything. And these are all presentation of information which are not entitled to patent. Example is speech instruction in the form of printed text, where horizontal underlining indicated stress and vertical separating lines divided the works into rhythmic groups, is held not patentable. If you're familiar with the language of music, wherein you have got certain things which I may not make sense, some of you might make sense, and that also maybe a person who is known familiar with that will understand how the music should go, how rhythmatic it should be, and where should it go, up and down and all those. And even that is a coding, that's a presentation recognition, which will have problems under section 3N. Going to 3O, topography of integrated circuits for obvious reasons of semiconductor integrated circuit layout designs Act 2000. For the presence of that, it's not patentable, though it is a technical information, scientific information, which comes there. Coming to P, an invention which in effect is traditional knowledge. We've got very many traditional knowledge in India. I may not have to explain what it is, though still we do not have all acceptable definition of traditional knowledge, but traditional knowledge is known to us. A traditional knowledge, or which is an aggregation or duplication of known properties or traditionally known component or components, then it's not patentable. Traditional knowledge being knowledge already existing is not patentable. Like the antiseptic property of turmeric for wound healing, it's already known. I think this will make a contextual sense. You must have seen this in so many advertisements. Now, for that's about section 3. We will read section 4 also along. Inventions which are not patentable. We will continue with that under section 4. And section 4 says that for inventions relating to atomic energy, no patent shall be granted. Do you identify this particular thing, object? Anybody can identify this?
It's an atom bomb. Yes. I think Fat Man.
Yeah. Little boy, Fat Man, and you have got very many things. This is Abhi, right? Abhijit.
Yes, sir. Yes.
Yeah, you are right. You are right, Abhijit. You're right. Here there are. It will be referred to if it's felt by the patent office concerned that this is something relating to atomic energy, it can be referred to central government, and central government will have an opinion on that. It's based on that will be decided whether it's an invention relating to atomic energy. And if it is found that it's related to atomic energy, then no way you get a patent on that. That's a position. I think with this, we, even though a very lengthy discussion is possible on section 3 and maybe on 4 also, we may not go for that. We just flip through, I would say, section 3. So as far as patentable invention is concerned, patentable invention should comply with all the positive requirements under section 2, like novelty, inventive step, and what you call utility. And the negative requirements, like it should not fall within these clauses, which we read through and we understood now. So this is how you may have to understand a patentable invention. 3 requirements to be complied with, and very many things into which you should not fall trapped. Okay, so invention relating to defense to be referred to central government, the secrecy direction to be periodically reviewed, and things like that. Now we understood what are the requirements of a patentable invention. Now, how to obtain a patent? That's a question that should follow logically. That's how it's it's arranged as well. Now the question is obtaining a patent. Put in simple words, registration is compulsory. In the sense that if you patent and if you don't invent, if you publish, you perish. Because you don't get that exclusive right. That exclusivity is the lifeblood of patent right. It's a kind of monopoly. That monopoly right you won't have. On the contrary, if you invent and if you go for a patent, though not sure, you are likely to prosper. It's not that every patent will become a hit. It will have currency in the market. It may not be so. To my understanding, a substantial number of patents are just patents on paper. may not be much useful in the market. But whatever it be, registration is a precondition for having a patent right. So moving on, who can apply? That's a no, next question that should appear. It says true and first inventor. It would appear to be a commonsensical understanding, which need not be stating the obvious. You might feel like this, but there are historical reasons starting from 1624 in England, which is a predecessor of patent law, which provided for giving a kind of monopoly, which is considered to be the predecessor of patent. At that point of time, the requirement was not inventing, rather inventor was one who was a person was considered to be inventor or eligible for this kind of monopoly known as patent. The person who is bringing that from other jurisdiction. It's understood that UK was not that very advanced at that point of time in the 17th century. So the countries like jurisdictions like Germany were much advanced. You still feel that because if you think of any high class automobile, it's from Germany. Perhaps some are from US and UK, but most of them are from Germany. So that was just a by the way comment, obiter dicta. So as it was not the requirement at that point of time, but when the time passed by, it was important for the law to state that it's only for true and first inventor patent shall be granted. I think I made the point. And second one is assignee of true and first inventor. Assignee is a person who gets a transfer. This is an intangible item. In the case of intangible item, transferee is known as assignee. And as far as this is concerned, this assignee of true and first inventor is another person who is entitled to make an application for patent under patent law. And third one is a legal representative. Legal representative, as far as the legal person is concerned, the entity which is entitled to represent that company under law. And even in a biological sense, like in the ordinary human being sense, also this is the same. Maybe the legal representatives who can you can represent you in case of untoward event of you being joining the majority, dying. Legal representative will be able to, or rather entitled to make an application for patent. And there are certain clarification with regard to true and first inventor. I may not spend much time on this. True and first inventor does not include, this is an exclusive definition, either the first importer. I gave the reasons for this kind of an explanation or definition already. This historical. True and first inventor does not include. At that point of time, during the statute of monopoly period, it meant differently. So now it is clarified that true and first inventor does not include either the first importer of the invention into India or a person to whom the invention is first communicated from outside India. So the reason is obvious and it is stated. And there is a case which is important, but I won't. I would go to the facts and circumstances of the case. The point here is the firm, corporation, or a legal person cannot be true and first inventor. An inventor can only be a human being with flesh and blood like you and me. Such an entity cannot have the capacity to invent. The capacity to invent would mean inventive faculty, skill, or the capacity to invent. That cannot be imputed. Patent law does not impute that to a legal person. Legal person may become an assignee, but an inventor as such, cannot be a legal person like company or firm. Here in this particular case, the issue was there was a partnership. One of the partners invented something. So the co-partner claimed his inventorship in this, saying that this is a partnership and this is as anything that is invented by one of the partners will go to the partnership. And if it is going to the partnership, then I am also entitled for that. This is how the law was trying to be, law was this was the interpretation put to the court, but court did not accept that. Court said it is only a human being and that can be an inventor. and a legal person cannot have the faculty of inventing. Let's see how things will go once AI is in place very strongly. Artificial intelligence is in place strongly. I don't know what's going to happen in future, but as of now, this is the position of law. Moving further with this, and next question is how to obtain a patent. Registration is a compulsory procedure, and registration is an important matter we may have to discuss in the patent, because no, the process of patenting and the registration procedure, etc., is important from different angles. If you're merely trying to understand patent law, that's important. Even from examination point of view, it's important. So let us discuss that. Now the matter is, by the way, do you have any clarification to make? Do you have any clarification to make? Anybody? Anybody?
The clear answer.
It's clear, right? Yeah, that keeps me in good humor. Yeah, thank you. If it is in fact clear, thank you. So, certain opening sentences on patent registration. An application for a patent should be made for one invention only. What is one invention is something to be discussed, taking some examples. But we may not have enough time for that. One invention is, it results in a single thought, and it results in a single device. A different form of a single device may not be a problem, but the thing which we talked about, we are going to have an example here. I've got an example here which is available in the patent site, patent office site itself. If you're thinking about two things, two kind of devices, and if you're trying to make an application for both in the same, both together, then it is not allowed. These are some general, little bit vague statements which will be better concretized later on when it comes to further discussion, I hope. It should be made in Form 1 along with prescribed fee as specified in the entry 1 of a schedule of patent rules. We have got patent rules as well. So a patent rule has got schedules. Fee prescribed is there, and we are not going to discuss that. In that, forms are also available. Form 1 and the first schedule also may be looked at. Application for patent should be filed with relevant patent office. What is this relevant patent office? Relevancy is connected with territorial territory here. If you are a Madrasi, like Madras Patent Office, there are 4 patent offices like Madras Patent Office, Chennai Patent Office, Mumbai Patent Office, Calcutta Patent Office, and you have Delhi Patent Office also. And it has got jurisdiction territorially. And as far as people from South are concerned, it is Chennai Patent Office, and likewise it goes. So it is a relevant patent office. Here, one of the questions that these are the zones, and these are the Controller General of Patent, Design and Trademark. Patent Office head office is in Calcutta. You've got branches at Mumbai, Chennai, and New Delhi, and the concerned regions are also on the screen. You may have a look at that. As far as Chennai Patent Office is concerned, it's South Zone. Andhra Pradesh, now it is divided into Andhra Pradesh and Telangana. Then Kerala comes under that, Tamil Nadu, Karnataka, Pondicherry. It goes like that, Lakshadweep, etc. And every patent office has got a territorial jurisdiction like that. So which area do you belong to? That will decide the relevant patent for office for you. As far as a foreign applicant is concerned, which is a relevant patent office, that could be a question that should arise. That should be a question that should arise, because in India, majority of the patents are held by foreigners. So appropriate office for a foreign applicant is concerned is determined according to the address for service in India. They may have an address for, they will have an that is for service in India. If it's in Mumbai, then it comes under that. If it is in somewhere near Hubli, then it will go to the relevant patent office. So it's like that. And now we have something known as specification. I'm emphasizing this because this is the most important document as far as patent registration is concerned. Specification. Specification is a techno-legal document. What you describe in the specification, which is filed along with the patent application, is technical details, but in a legal way, complying with the legal requirements and patent law and the concerned rules. So what you present are technical information. So in a way, this is not in a way, it is a technical document, but it should be in the legal framework. Legal requirements should be complied. You should be presenting these technical information in a legal way. That's the idea there. And application, when we say application, it's patent application. Patent application is to be accompanied by a provisional or complete specification. Provisional would mean provisional, as we understand. Before you get the final degree certificate, usually you get provisional. Provisional is only provisional. It's not complete. It's not final. It's subject to condition, I would say. So a person or the entity which is making an application of a patent will be allowed under patent law to make a provisional specification even if you have not reached a stage of fully demonstrating before the patent office what's the kind of invention you're coming out with. If you have just transcended the conceptual stage, you are sure that you will be able to reach the result, then you will be entitled to file a provisional specification. Provisional, there is a provision for provisional specification because this is to tackle the problem of priority of people. There will be competing applications, competing people who will be making application for patent, because patent is a kind of monopoly, and many times if the patent is so important a one, it will give you a world market sometimes. So there is a lot of money involved in this, a lot of competition in this, a lot of commerce in this, lot many things would come into this. So here, a person who is claiming a true and first inventor and who makes a provisional specification, he gets a date of priority from the date of provisional specification. He is first in the queue. Any person who comes next will be next in the queue. The person first in the queue will be considered first. And the person who has made this provisional specification has to file a complete specification, which is the final thing, which will be considered by the patent office for the purpose of for verifying whether what you claim is in fact is a patentable thing or not. So a complete specification should ordinarily be filed within 12 months, which can in rare cases extend to another 3 months. Ordinarily, it is for you should be able to file the complete specification in 12 months from the date of filing. What you call provisional specification. Now, for provisional specification and priority date, I just gave you the idea there. The provisional specification discloses an invention at a conceptual stage. 12 months to file complete specification, which is already put across. And the most important thing there is priority date. Priority date is a crucial date as far as the patent applicant is concerned, because it is first come, first served basis usually, unless you can prove that you have certain rights. Your right dates back to a date which is prior to the current priority date of the person concerned. So moving further, a specification complies with the requirement of patent literally. To make something patent would mean that you are just disclosing that. You may have to understand that in contradistinction with latent, A latent defect and patent defect are something which we might have discussed, you might have discussed when it comes to Sale of Goods Act and things like that. When it comes to goods guarantee, warranty, etc. Here, patent would means by making a patent application, you are ready to make this known to everyone. You are giving all the information relating to what you have to the patent office, which is a representative of the society. You are disclosing that to the society as a quid pro quo for this, something in return for this. You are granted monopoly right for 20 years. That's a theoretical understanding. That's how it goes. So the disclosure requirement, a would-be patentee should disclose his invention through the best method known to him. And that requirement is complied with through the document known as specification. In the specification, you should disclose the best known method, though usually people do otherwise. Least things known are disclosed through specification many times, but it should be examined. If it is not a proper disclosure, then you may not be entitled for a patent. So anyway, the important requirement of disclosure, apart from novelty, inventive step, and utility, you will have to disclose this also. And disclosure requirement are complied with, or it is mandated through the filing of a proper specification. So moving on with the idea of specification. Specification should give, or ought to give a full and particular description. Please note the words used. A full and particular description. It should be a complete, comprehensive description, and it should be very specific. Particular description of the invention and its operation or use, because you are just describing the device. That by itself is not sufficient. You may have to describe the operation of that, or even operation and use of it, and the method by which it is performed, and how it is performed. So you'll have to describe the device if it is relating to a device, mechanical device. Then how does it operate? What is the use of that? And what's the process of operationalizing it? What's the process of working with that? So a complete understanding of that, a comprehensive understanding of that should be provided in the specification. Now, best method. Best method may be easiest method, less cumbersome method, less expensive method, which came to your knowledge, which you are familiar with. So the best method of performing the invention should be particularly and completely comprehensively described in the specification. Now, moving on, you have got certain parts. You can identify certain parts for a complete specification. I'm fully aware that time is almost 7. It's touching 7. I'll just list this out and leave it at that today, and we'll go for the further discussion of each and every part of this in the next class, next interaction. I would say, I don't want to say class because you're all teachers. So every specification will have a title of the invention, field of invention will be mentioned, then background in which this invention becomes relevant, that will have to be explained. Object of invention, what's the aim of the invention, that is to be made clear. It's all commonsensical and logical. Then you will have to state what is your invention. Then a summary of invention is to be given so that people will be able to know what the invention is all about. They may not have to go to the entire specification to understand about the invention, patent. A brief description of accompanying drawings, which will be there in many of the cases, because as you're giving a description of a technical thing, it can be explained better through pictures and drawings. So that will be there. And detailed description of invention with reference to drawings and examples. That's the 8th part. And you have claims. Claims is very important because your patent is what is claimed. So what's the extent of your patent right? That will be determined depending on the extent or scope of your claims. Mere description in the body of the specification may not matter much. It matters for the purpose of interpretation of claims, but even if it is described, but if you omit to claim that in the claims, then your patent is less wide. Scope is narrower to what you have not claimed, and you will have an abstract too. So these are the 10 parts you may identify for a complete specification, and we may have to understand each of these in some detail. We may not go for very deep into this. We may not go very deep into this, but we will definitely have a basic understanding of each of these through an example. But we will do that. But we will do that in the next class. If you have any clarification to make, we will do that right now. Otherwise, that's it from my side for the day.
So I had a doubt.
Yeah, Pooja.
Sir, with regard to that sentence, a patent can be granted only to one invention. Is it like that? It's not like that, no? For example, in the case of mobile phone, at a time we can grant so many patents, no?
Yeah, with regard to, good question. A fundamental question. Yeah, how do you understand that? I'll explain it this way. There are lakhs of patents existing even now, to my knowledge, to my reading, to my knowledge, with regard to a mobile phone. But each of these patents will pertain to a small part of a mobile.
Okay, sir.
It's not for mobile as such. A small part of a mobile which functions in a particular way. So that patent will be with regard to the invention which is made possible, the function of that particular part. Take for example, mobile is already existing. You have a black and white mobile, and for the first time, I come out with a color mobile, a color screen mobile. So I will have an invention for the color screen of a mobile. That is one invention. Another person might come out with another invention wherein you can play music as well. So that person will have one invention and one patent with regard to that one invention pertaining to mobile, which will enable, or rather enable the patent, mobile makers to have that function also integrated into this particular device. So, but that invention is with regard to that music alone. This is with regard to color screen alone. All these are single different inventions.
Okay, sir. Okay, thank you so much. Okay, clear. It's clear.
Thank you for the question, because you are following me. That's it's a hint for me. It's a hint for me, and I'm happy about it. So that's it for the day. If you have any, if you don't have any more questions, tata bye bye. Thank you. So with your permission, I think Safi sir is there. Is he there? Yeah, Safi sir, thank you so much. And
thank you, sir. Thank you very much. Thank you.
Thank you.